what can be found, how things are done. The third presentation is different. It's about the legal aspect. It's that thing that many of us are quite afraid of. Nathalie Falot from the Netherlands, senior legal consultant from Considerati, has done research in this area. What's the legal status of ethical hackers? And welcome, Nathalie. Give applause.
Thank you very much for having me, first of all. My name is Nathalie Falot. I'm a senior legal consultant in the Netherlands, and I'm also an in-house consultant for the Dutch National Cybersecurity Center. And I've done some research on the position of ethical hackers in the EU from a criminal law perspective. So hacking, from a law perspective, was first implemented in law through the Convention on Cybercrime, or the Budapest Convention, which was signed in 2001 and has 49 signatories up till date. And in the EU, it's also been implemented in the Directive on Attacks Against the Information System. What it has in common, and what most hacking provisions across the EU have in common, is that it's about illegal access to an information system, or a part of an information system at the least. So hacking is a criminal offense in almost every EU member state, or actually in every EU member state, hacking is a criminal offense. So you can be punished with financial fines, but also with prison time. So we've got the Convention on Cybercrime, the directive, but we also have national legislation. So the directive, since it's a directive and not a regulation, is implemented into national law and leaves member states room to make the provision in a way that they feel comfortable with. So the provision on hacking can be broader in one member state and less broad or stricter in the other. And that's important if you want to look at hacking or ethical hacking in cross-border cases. So how did we do it in the Netherlands? We actually got quite a broad provision, but it has some points for giving us some room to take the ethical motives of a hacker into account. So in the Netherlands, we say that hacking is purposefully and unlawfully entering an information system, or an automated work as we call it, or part thereof. And purposefully, you'll have most of the time. So if you hack, you do it with a purpose to enter the system. So that's from a proof perspective, it's not that hard to prove. But unlawful, that's where it gets interesting for lawyers. So when is behavior unlawful? And do we have some mechanism to say when behavior is lawful and when behavior is unlawful? What's also interesting in our provision is that you do not necessarily have to breach security measures to be hacking, which is something the Convention on Cybercrime states and the directive states as well, that you should at least breach security measures. We have a bit of a broader sense in which we say, well, breaching security measures is only one way to enter an automated work. The others are through technical interference, through false signals or false keys, or by assuming a false identity. So the question I asked myself when I was confronted with this issue is, can we state that ethical hacking is lawful hacking? Is there such a thing as lawful hacking? And just to get a feel of the room as well, I've got some examples of cases that happened in the Netherlands that really got this discussion going in our state. So it doesn't matter if you're a white hat hacker or a black hat hacker from a legal perspective. So this is the first case I wanted to discuss with you. At Lego Steentje, which would be Lego block in English. Marktplatz is an online marketplace in the Netherlands owned by eBay. eBay is not active in the Netherlands except for that they own Marktplatz. And it's an online marketplace where you can trade secondhand goods and new goods, etc. And at Lego Steentje was an intern at one marketing or online marketing company. And that online marketing company had access to an ad network or an ad space on the website of Marktplatz. So as an intern, he was asked to use that market space or that ad space and do the marketing activities. And as a good hacker, he thought, what can I do with this ad space? So can I inject code into this ad space to make it do something that it's not supposed to do, as a lot of hackers want to? And he found out that he could. He could inject code that would enable him to do cross-site scripting on the website, thus luring people away from the Marktplatz website to another website that might not be as legal as Marktplatz would hope that their ad users used. So the question is was he allowed to do that? And if so, how would Marktplatz react? So do you think Marktplatz should press charges if something like this happens, if someone misuses their ad space or tries to find vulnerabilities in their ad space? So show of hands, who thinks they should have pressed charges? One, good. The rest, all of you think that that should be possible. You should be able to do that. It should be allowed. Let's wait for a microphone.
The thing what happened that was it done for the profit? Basically, was it done for the profit of his employer or his personal profit?
Should that matter? Should it matter that you do it for the profit of your employer or for the profit of Marktplatz? Should that matter? It is indicate when you talk about unlawful behavior, your motive is quite important. So yeah, what he did was he just wanted to find out. He didn't really have a motive. He just wanted to see if it was possible. But when he found it, he was really afraid that Marktplatz would press charges. But he also was afraid that this vulnerability would be exploited by malicious hackers. So he really carefully posted a tweet to Marktplatz and said, well, I found something, but I'm really afraid to disclose it to you because I'm afraid that I will be faced with criminal charges. Now, Marktplatz is extremely mature when it comes to responsible disclosure. So they already had a policy back then, which is in 2011 or something. And they said, we are very interested to hear what you have to say, and we want to fix it, so we would like to talk to you. It took a while for them to really get in touch. But Marktplatz was extremely mature about it and asked him to do a full disclosure with them, but not publish it anywhere else until they had it fixed. In the end, they actually offered him a job. So they were very happy with his skills, and they were very happy to have him on their team. And in the end, he went to do something completely different. Another case, we have, yeah, there's a question. It's okay.
So whatever that guy, the previous guy did, he gathered some private information from the potential buyers or users of the page.
No, he didn't collect any information. So all he did was check if cross-site scripting was possible, and then he stopped. So
okay.
Just the fact that it was possible was something he wanted to disclose, so they could fix it. Second case, the Green Heart Hospital. So we've got a huge hospital in the Netherlands. They've got a lot of patient files. And a hacker hacked into their FTP server. And he found out that it was quite easily done. And he went with the information to a research journalist in the Netherlands. And he said, research journalist, I myself do not want to be involved in this. You are a journalist. You've got journalism protection in the Netherlands. So could you contact the hospital, tell them about the vulnerability, and make sure that it's fixed? And later on, we want to disclose it in an article more broadly. Now, who thinks that that's the right thing to do? Show of hands. Who says yes, you're allowed to do this? You should be able to go to a research journalist. And who says no? So it's a bit divided then. The court in the Netherlands said it's okay to go to a research journalist because journalism is important as well. And as long as the journalist is known for being mature about it as well and being responsible about it, you should be able to contact such a person to stay anonymous yourself. So that wasn't the problem. But at a certain point, he came back, he hacked the server again, and he started downloading patient files. He started checking if he found friends or known people in the database, see what their problems were. And that's where the court said, well, you're not allowed to do that. So you're allowed to check for the vulnerability, you're allowed to disclose the vulnerability in a responsible manner, but you're not allowed to download files, to check for files, to search for names, because it's not necessary anymore. So now you're doing it for personal gain. Has anyone heard of this case, the Megachip case? Some of you have, some of you haven't. Now this is where, for me, from a cross-border perspective, it gets interesting. because the Radboud University of Nijmegen found a vulnerability in the Megachip chips that are used by Volkswagen for anti-theft and locking your car and not being able to start your car. So the Radboud University found the vulnerability and they disclosed it to the owner of the chip, to Megachip. Megachip didn't do anything with it. They got a reasonable amount of time to fix it, but they didn't. And the university said when they disclosed it that they would set a reasonable amount of time to fix it, but after that they wanted to disclose the vulnerability, show off their research at a big cybersecurity convention. Now the owner of Megachip didn't do anything, but Volkswagen heard about it. They heard that they were about to disclose this vulnerability at the convention. So they said, we don't want that. Like, hundreds of thousands of people use these chips, use their cars. If this gets out, then our cars will be stolen. Now, who thinks that the Radboud University should still be able to disclose this at the convention? Some of you do, and the rest no? No? Okay. Now this is, for me, it's really interesting, because in the Netherlands, we would probably say that they were allowed, because they gave a reasonable amount of time to fix the vulnerability. They went to the owner of the information system with it, and it's their responsibility then to fix the vulnerability. However, because one of the researchers, by the time it went to court, was living in England, the case was brought before a British court. And the British court said, no, you're not allowed to do that. You're not allowed to disclose this case or this vulnerability, because it's just not in the interest of Volkswagen, and Volkswagen might actually be in an extreme disadvantage if this gets out in this way. So you're not allowed to disclose it. Now, so you have not only the owner of the information system to think about, but also other interested parties, so third parties that use the information system or the software or hardware involved. So this sparks a lot of discussion, especially across the EU. When I went to the Friends of Presidency meeting, I found a lot of discussion and a lot of uncertainty about responsible disclosure from a legal perspective. One of the biggest questions was, if we do responsible disclosure, do we condone criminal behavior, since hacking is a criminal offense? And these are questions we will see later in the panel as well. But for the Netherlands, we feel that responsible disclosure is a very good middle ground between security through obscurity, so just not publishing anything and make sure that nobody knows anything about the vulnerabilities, and full disclosure, where everybody gets the same information at the same time. So we feel that responsible disclosure or coordinated vulnerability disclosure is a good middle ground between the two. So if you have the process of vulnerability disclosures, this is a sheet by ENISA, the European Network and Information Security Agency. You see a lot of steps going on, and the responsible disclosure from the ethical hacker kind of side focuses on the discovery and notification, the first notification, and the release of the vulnerability to the broader public. So how do we in the Netherlands establish lawfulness or unlawfulness of the behavior when it comes to ethical hacking? So where do we see the ethical part in this discussion? So first of all, we say our public prosecutor has this policy, they follow this policy, and so do judges now. So we've got some good case law in which this policy is followed. And what we say is that, first of all, you've got to check the motive. So did you do this in good faith? Was your purpose not personal gain, as you so nicely mentioned already, but did you do it, for example, to improve cybersecurity as a whole? So do you want to use this information to improve cybersecurity? Do you want to improve the security of this particular system? Do you want to help the manufacturer or the organization or the people using it? So you need to have good intentions when doing responsible disclosure, when searching for vulnerabilities. But it's not all that. So what the judge, for example, in the hospital case said, because the hacker said, well, I had good intentions, I wanted to show the Netherlands that this hospital has their patient records out on the street for anyone to grab them, so I have good intentions. So the court says, well, that's good, but just stating that you have good intentions is not enough, plus only having good intentions is not enough either. So the public prosecutor would have to check and have to find circumstances that prove that you had good intentions, but that's not it. So he also has to check if your behavior was proportionate. And like proportionality and subsidiarity are vastly majorly used terms in legal landscapes and legal frameworks. So you always have to be proportionate and subsidiarity. And proportionality actually states that you should not do more than is absolutely necessary to prove the vulnerability. So as soon as you've proven it, you should stop. You shouldn't go look for any more or see how far you can go after that. So the first vulnerability is what you need to prove it. As soon as you've done that, you should stop. Do not download files if it's not necessary. Do not check any more than you have to. And the second is subsidiarity, which means that if you disclose the vulnerability, you should first go to the owner of the information system. And you should tell them what vulnerability you found, maybe even help them fix it if you know how to, before you go to the broader public. And going to the broader public is quite discussed if that has to be coordinated or not. In some cases, we do promote it, so we do try to make sure that the hacker and the organization agree on a time frame before you broader publish the vulnerability. But it's not absolutely necessary to agree on that, as you could see in the Volkswagen case, where the manufacturer did absolutely not want to publish it, as well as the user of the keys. But it has to at least give a reasonable amount of time, and you have to go to the organization first. So that's the principle. Now, in the Netherlands, this system kind of works. Ever since we introduced responsible disclosure, and we've got a government policy for it, and we've got a lot of companies having responsible disclosure policies, not a single case has been referred to court. So it works. It might not be the best legal framework, but it works. Now, I had to ask myself, how does this go in cross-border cases? So if a Dutch ethical hacker were to hack into an information system in Germany, for example, you don't always know where an information system is situated, you don't always know where you are, so how about your criminal liability in those cases? Well, in the Netherlands, you feel quite safe doing responsible disclosure. How would you feel if you were entering an information system in Germany, for example? So there are three factors you have to take into account if you research this from a legal perspective. First of all, is extradition possible? Can I be extradited? Will I face a foreign court or not? The second is criminalization of hacking in that other member state. So how do they criminalize hacking? And the third is the applicability of responsible disclosure in that member state. So does public prosecutors or organizations in that member state have the possibility to apply responsible disclosure, and thus make sure you do not face criminal charges? So extradition within the EU, we've got a framework decision for that, to make extradition more easy, actually. And one of the articles of the framework decision states that if the offense in the issuing member state, so the member state requesting the extradition, is punished with a maximum sentence of at least 3 years, then double criminality does not apply. And double criminality means that usually you do only face extradition if the act is both a criminal offense in the member state you're a resident of and the member state issuing the extradition order. So double criminality does not apply, only criminality in the issuing member state applies. And they've got a list for that, for the kind of offenses they want to exclude double criminality for, and computer-related crime is one of them. So extradition can be done if hacking is illegal in the issuing member state and sentenced with a sentence for at least 3 years. So how do we do it? I checked for 2 member states because I didn't have time to do it for all 28. But in Germany, for example, they have a really broad classification of hacking. So a lot of behavior can be constituted as hacking. And unlawfulness is not an element there. Detention of maximum 3 years, so extradition to Germany could be possible from the Netherlands to Germany. In Belgium, they've got 2 forms of hacking, internal and external. So internal would be within your organization, external would be from the outside into an organization. And they say external is any form of attack. Unlawfulness is not an element, and the detention varies, but can be up to 3 years. 5. Now, I hear knowledgeable audience, that's good. So, how is it punished then? Because both to Germany and Belgium I could be extradited. So what do I face when I go there? Do they have responsible disclosure there? Can I make a case based on a responsible disclosure argument? Now, in Germany, hacking is what they call an Antragsdelikt. So that means that the public prosecution cannot prosecute without the organization having pressed charges. So the victim has to have pressed charges. That means that in Germany there is room for self-regulation for responsible disclosure. If the organization complies or says that they will not press charges, you have quite some legal certainty there, that if you do a responsible disclosure, you will be not extradited to Germany. But if they press charges, the public prosecutor has to investigate, which is different from the Netherlands, where the public prosecutor has the principle of opportunity and can choose not to prosecute even if charges have been pressed. So criminal liability in Germany really depends on how the organization sees responsible disclosure, if they're open to it, if they would commit to not press charges. In Belgium, the public prosecutor can make a policy on criminal investigations and prosecuting, but they have no such policy for ethical hacking or a computer crime. And the DOJ stated that any form of hacking, even with good intentions, is unlawful. There's little to no room for justification of hacking in the legal system, but Belgium is working on it. So in January of this year, they said that they wanted to create a policy or at least some form of framework for ethical hacking. In August, they said that they want to finish that framework by the end of the year.
Maybe just also, I'm from Belgium, so I'm a little bit
Welcome.
biased. There's one thing that you should take into account is that indeed, you're right, everything is hacking. However, most of the times if they catch people and they bring them to court, they get a conditional sentence of 5 years, which means that they're off the hook, but if they do it again, then they go behind bars by default.
Thank you for that detail. So by the end of the year, Belgium hopes to have a more sustainable framework for ethical hacking as well. Now, what's the future for ethical hacking? So I'm not the only one who says that there is little legal certainty in cross-border cases. ENISA agrees with me. I'm not sure if they know that, but in their report on their good practice guide on vulnerability disclosures, one of the conclusions of the ENISA research across the EU was that the need for an advanced legal landscape is there. So from a legal perspective, we have to look at responsible disclosure, we have to look at hacking provisions, and we have to see how we want to regulate this in a more broader EU sense. So at least within the EU, you would have some legal certainty across member states. What they kind of well pointed out is that responsible disclosure and hacking is not only from a legal perspective, not only from criminal law, but it can also be from civil law. So you could also infringe on copyright, on intellectual property. You could have tort law come in, privacy laws come in. So I did not include those in my research, but there's something to keep in mind if you're talking about implementing responsible disclosure. How do you face, for example, breach notification requirements in the GDPR? If you invite ethical hackers to hack your systems, and personal data is part of that system. Another initiative that was launched this year, in May of this year during the Dutch presidency in the EU, is the Responsible Disclosure Manifesto, which has been signed by 29 organizations, both national and international. And this is a commitment by private organizations to introduce responsible disclosure, to create a responsible disclosure policy for their organization, but also commit to trying to talk to their local governments, or their national governments, about responsible disclosure in that member state. The manifesto is just there. It started in May of this year, and it has been endorsed by the GFCE, so the Global Forum on Cyber Expertise. And they invite every organization to start talks about responsible disclosure and see how they can do it in a more processed way. So my conclusions on this subject. At this moment, I feel that there's little legal certainty regarding criminal liability of ethical hackers in cross-border cases. So you're extremely vulnerable, and you're kind of left to the law of the member state you're hacking into. For Dutch ethical hackers, I always say try to keep it in the Netherlands. Because in the Netherlands, you have quite some strong legal certainty. You know what will happen, and you know how far you can go. How could you improve this? So how can we improve vulnerability disclosure across member states? First of all, we need to have international views on what kind of behavior we feel is acceptable. And in the Netherlands, at the moment, we do a case by case. So we invite organizations to share some cases with us, but we also see that, well, if an organization is not so sure about, for example, the motives of the hacker or how far he went, they can always go to the public prosecution and it will still be researched and the court will decide at the end. So it's a case-by-case approach. International views on what we find acceptable would really help in that regard. Also cross-border cooperation. So we've got CERTs that work together already. The new Network and Information Security Directive will create a CERT network, which might get a role in this subject as well. Just to make sure that if you have a responsible disclosure in another member state, you could maybe get some help from the CERT or the CERT of that member state. And the last is cross-border legal protection, and that's really difficult. Like, creating the legal framework in cross-border cases to harmonize legal certainty across the EU for this kind of practice, which is quite arbitrary and, as I said, will mostly be considered on a case-by-case basis. It's hard, but I don't think it's impossible. But it will need a lot of work. Latvia is now working on a legal exemption for governments, if I'm correct. So it is possible, but it's also a challenge. In the Netherlands, we try to stay away from the actual legislative questions because we say the unlawfulness element in our hacking provision leaves room for the 3 steps. So the motive, proportionality, and subsidiarity. So that's my presentation, and if you have any questions, I would be happy to answer them.
Questions, comments?
So that intra-EU extradition got me a little worried. So where, at what point can a EU state decide that they want to prosecute something they think is illegal? I mean, so for example, if I were to find a vulnerability in Latvian government system containing only Latvian citizens, could Belgium still, say, hey, we don't want that to happen and extradite me? And then for a second question, a bit more complicated case, let's say the system also, in addition to Latvian citizens, contained 1 Belgian in there.
Yeah, that's a good question. So usually it's the owner of the information system would have to press charges. And it depends on where the owner is situated. So if a Dutch ethical hacker were to hack into an information system in Latvia, and the Latvian organization would press charges, then they could go to the Latvian police. And if the police wants to investigate, they can ask for an extradition order, which would go through international cooperation. And the extradition order would be sent to the Dutch police, and the Dutch police the Court of Amsterdam would then decide if that Dutch citizen would be extradited to Latvia. If personal data of a third party would be in there, then it depends how strong a case they have to press charges themselves. But I'm not familiar with a case like that, but in theory I think it could be possible, yeah, that you have different countries claiming jurisdiction in a case like this.
Hi, me again. Small question. In your expose, you didn't mention that, well, first of all, there's the liberty, of course, of the public authorities to prosecute or not. Public prosecutors can decide themselves if they prosecute or not. And isn't there, in your opinion, a difference between the private and public sector? In that sense that the private sector has to prove that there's damage before they can ask somebody to be prosecuted? Because that's my feeling is that if a private company cannot prove that there's damage, real damage to them, then public prosecutors will drop the case?
Whether public prosecution can actually prosecute really depends on the member states themselves and the provisions they have. So in certain member states, damage could be one of the elements that they have to take into account. In the Netherlands, we don't qualify damage for hacking. So you don't have to have damage, but just because if you go into someone's personal files, for example, with the hospital has huge damages, but not because of what the hacker did, but because of the security measures they had to take afterwards. They had to spend millions to try and secure their systems again. So damage is something that will be taken into account, for example, for the punishment of the hacker in the Netherlands, but it's not so much a requirement for prosecution, but that can differ per member state. In the Netherlands, public prosecution has a lot of freedom to choose whether they prosecute or not. In Germany, for example, they have to prosecute as soon as there are charges pressed. So that's the way a public prosecutor can choose to either prosecute or not really differs across the EU, and that is an issue. Yeah.
Anyone else? No? Okay, let's, yes. No.
Thank you. So I have the question about the process in Netherlands. You have mentioned one small thing. I'm just trying to understand if I've heard it correctly. You've said that if you find one vulnerability, it's at least not advised to continue further. Does it mean that you cannot, after you find one vulnerability, you shouldn't be searching for any vulnerabilities connected to this product or company, even if they are completely different?
You are allowed to search for different vulnerabilities, but what you're not allowed to do is enter a network through one, and because you found that vulnerability, you get into a layer with maybe other vulnerabilities, but that if you wouldn't have found those without the first, you shouldn't go there. So if there are different vulnerabilities, you're allowed to research as much as you want. But once you found the first vulnerability, you should not try to find consecutive vulnerabilities to the first.
Okay, last one.
Yeah, I just want to add up on the previous question. I believe like when, for instance, in case of medical institution, when you start searching for medical records, that's like exploitation of vulnerabilities. So I believe this is not allowed, but finding new vulnerabilities is totally okay. Am I right?
Yeah.
Okay, that was a short one. One more hand? No. Okay, let's thank Nathalie. Thank you very much.
Thank you.
And this brings us to coffee break, but responsible disclosure topic is not over. We will continue here at 3:40, the panel discussion, and there will be also 2 parallel rooms, but I hope to see you back in 25 minutes.